Good day, everyone. Now, to formally start the discussion, in continuation of the Title 4 of the Revised Corporation Code of the Philippines, today we will discuss the remaining powers, which is the powers of the corporation to declare dividends and the powers of the corporation to enter into management contract. Of course, we will tackle also the last section in this title, which is Ultra Vires Act of the Corporation. Now, let me introduce to you the topics to be discussed, which will be the sequence of today's discussion. Kung mapapansin nyo, from 1 to 6, it is all about the section 42, while yung number 7, it is all about the section 43, the management contract, and lastly, yung number 8, section 44, Ultra Vires Act. Let's now proceed to the section 42, powers of the corporation to declare dividends. So before we proceed to the requisites, what is retained earning? Basically, retained earnings, the accumulated profits realized out of the normal and continuous operation of the business after deducting therefrom distribution to stockholders and transfer to the capital or other accounts. From the word itself, retained tsaka earnings. Retained, ibig sabihin natira or nanatili, while the earnings or sometime we call profit, it is about the excess money that the company obtained from the profit-directed activities or earnings that or earnings or what we call return on capital rather than earning from labor performed or services rendered. So the profits or earnings calculated by deducting the business expenditures and the retained earnings is calculated by adding beginning retained earnings plus the profit less the dividends. So retained earnings has two types. It is restricted retained earnings and unrestricted retained earnings. The restricted retained earnings from the word itself restricted, it is something can be done under certain condition. Ibig sabihin, yung retained earnings na yun is nakalaan for certain purpose that it cannot be used to pay for the dividends of the stockholders because it is a restricted portion of the retained earnings to use for specific purpose katulad ng expansion ng business or even yung portion of portion of the retained earnings is restricted because it is a part of the loan agreement na hindi mo pwedeng gamitin yung retained earnings na yun hanggat di pa napo-fulfill yung ng company yung loan obligation. While the unrestricted retained earnings are the retained earnings which have not been reserved or set aside by the board of directors for some corporate purposes. Unrestricted meaning that it is not subject to certain condition. So ibig sabihin, this is available for distribution of dividends. So to further understand the section 42, let us know the concept of dividends. The dividends is a corporate profit set aside, declared, and ordered to be paid by the directors for distribution among stockholders at a fixed time. So ano naman ang pinagkaiba niya sa profits? When we say dividends, it's a portion of the profit or net earning which the corporation set aside for ratable distribution among the stockholders. The dividend comes from the profits, while the profit is the source of the dividends. While yung profit is not a dividends, magiging dividends lang siya when it is so declared or set aside from the by the corporation for distribution. So yung dividends naman na na-receive ng company from another company is what we call the corporate earnings in which it arises to corporate investment. Next, we will jump into the requisite or requirements of the declaration of dividends stated from the first paragraph of the Section 42 of the Revised Corporation Code. First, the requirement is the existence of unrestricted retained earnings. Just like I've said a while ago, unrestricted retained earnings are not subject to the certain condition or specific purpose. Therefore, it is available for distribution of dividends. Kumbaga, dito kumukuha ng ipapamahagi na dividend sa mga stockholders. So, dapat may unrestricted retained earnings para magkaroon ng dividends yung mga stockholders in which pwedeng ibayad na dividends sa stockholders ay cash, property, or stock. The dividends are thus payable only if when there are profits earned by the corporation. But this unrestricted earnings does not give the right to the stockholders to get their dividend. There must be, second, the resolution of the board of directors that dito sa for the general rule that is that it is discretionary or optional on the part of the board. Sila lang yung makakapag-decide kung magde-declare sila ng dividends or hindi. Third, there is additional requirements with regards to the cash and stock dividends that was mentioned in the paragraph 1, section 42, that when it comes to cash dividends, if there are unpaid subscription, meaning binayaran mo yung subscription but di pa siya fully paid, that means your stock will be delinquent. So in that case, para di na siya maging delinquent, yung makukuha mong cash dividend will be applied first to the unpaid balance of the subscription plus costs and expenses. Then yung matitira ay mapupunta sa'yo. Dito yung cash dividends can serve as a cover to the delinquency of the stock. Remember, yung makukuha ng stockholder as a dividend is based on the capital stock or the amount of the stock that is stated in the articles of incorporation na kung ano equivalent nun per stock, not by the amount you paid for the stock. In the case naman of unpaid subscription, yung wala ka talaga binayad at all, hindi yun applicable in this section. This payment of subscription is considered illegal kasi yung mismong pera na makuha mo is ipambabayad mo din sa subscription mo. Eh di wala kang makukuhang dividend. Kumbaga parang wala na din nangyari kasi wala kang nilabas na pera. Hinantay mo lang na kumita yung stock. So take note that when it comes to cash dividends, and ang general rule is need ng approval ng majority of the quorum or meaning ng quorum, minimum of the directors who attend in the meeting kung kailan magde-declare ng dividends. So the stock dividends, kapag delinquent stockholder ka, hindi ka makakuha ng stock dividends unless na mababayaran mo ng buo yung unpaid stocks mo. So, ang mangyayari, mawi-withheld if it's still unpaid. Then kapag mag-i-issue ng stock dividends, in addition sa resolution ng board of directors, kailangan may approval din ng stockholders representing at least 2/3 of the outstanding capital stock at a regular or special meeting duly called purpose. Aside from that, there must be also a sufficient number of authorized and issued shares for distribution to stockholders. Siyempre, if you will declare stock dividends, there must be enough stock to be issued in all of the stockholders. Otherwise, if there is no sufficient stocks, pwede naman nila i-increase yung capital stock ng mga stockholders. Or meaning, tataasan yung amount ng shares in order for them to distribute the dividends. So dito, lagi yung tatandaan na dapat may unrestricted retained earnings para makapag-declare ng dividends at any time. Pwede mag-declare ng dividends as long as may approval ng board of directors. In case of stock dividends, dapat meron ding approval ng stockholders at least 2/3 ng outstanding capital stock. Now, what if there is an illegal declaration of dividends? Nangyayari to, for example, kapag nag-declare sila ng dividends, tas as a result ng at as a result nun, nag-incur ang corporation ng loss. Because of that declaration, here the board of directors will be liable in that loss and the stockholders should return the dividends to the corporation, which is in accordance with the principle of solution indemnity. Remember that yung dividends is dapat makukuha lang out of the profits or profits that are not held for any restriction or yung tinatawag natin na unrestricted retained earnings. So kapag nag-declare sila ng dividends based on the company bank balance rather than profits, that is an illegal dividend which is beyond the powers of the corporation. Now, that is what we call Ultra Vires Act. Later on, we will discuss that. Now, let's proceed to the two common classes of dividends, which is the cash and stock dividends. Basically, when we say cash dividend, it is refers to the dividends payable in cash. While the stock dividends is dividends payable in unissued or increase or additional shares of the corporation instead of cash. And declare lang nito based only to the extent of the maximum number of shares authorized in articles of incorporation. So now let's discuss in detail the distinction of the two common dividends. First, yung cash dividends is part of a general fund in which it came from the current earnings of the corporation or the accumulated profits that are available for distribution of profits or not subject to restrictions. While stock dividends is a part of capital since yung pag-i-issue nga ng stock yung pinambabayad. So, nagkakaroon lang ng additional investment yung stockholder sa company kahit hindi nag increase yung amount ng stockholder equity. Second, if the board declares cash dividend, it results in cash outlay in which the corporation have to draw money from its company. Well, if the stock dividend is declared, there is no cash outlay dahil nga nagkakaroon lang ng additional stock or increase in stocks or capital stock yung holder nito. Third, the cash dividend is not subject to levy by corporate creditors. Ibig sabihin lang nito, the creditors of the corporation cannot go after the money that has been paid to the stockholders because when the cash dividend is declared, napupunta na yung ownership to the stockholders and not to the corporation. Kumbaga, return of capital na siya ng stockholders or investors. On the other hand, since part nga ng capital ng corporation yung stock dividends, then corporate creditors can go after them since it is a part of the ownership of the corporation. Fourth, when cash dividends is declared, need ng approval ng majority of the quorum of the board of directors, kagaya ng sabi ko kanina. Kaya BOD lang need ng approval kasi sino ba naman stockholders ang magde-declare or hindi kapag magde-declare ng cash dividends, di ba? Return of capital nila yon. While when stock dividends are declared, the majority of the quorum of the BOD with the concurrence of the stockholders representing at least two-thirds of the outstanding capital stock is needed. Dito, need ng vote by the stockholders para malaman kung gusto ba nila na madagdagan yung stocks nila sa company or hindi. If hindi, kahit pa may approval ng BOD, kung di naman pumayag ang stockholders, wala din declaration na mangyayari. Fifth, the declaration of the cash dividend does not increase corporate capital since it is not part of the capital. Kumbaga dito nagkakaroon ng cash outlay, which is the decrease in the general fund. Then, yung mare-receive na cash dividend ng stockholder is subject to individual tax since profit or gain nga nila yon. Pero pag receive ng corporate, pero kapag na-receive ng corporation, it is not subject to tax kasi nagbabayad naman sila ng tax based sa kinita ng company nila. On the other hand, the stock dividends increase in corporate capital. Kagaya nga ng sabi ko kanina, nag-increase yung stock na ini-invest ng stockholders sa company. Kapag na-declare ito, it is not subject to tax kasi wala naman nakuhang pera yung mga stockholders out of that dividend. And it is still in the possession of the corporation. 6, the cash dividend declaration creates a debt from the corporation to each of its stockholders. Dito na pumapasok yung right to dividends since kumita nga yung company and nag-declare sila ng cash dividends, ibig sabihin obligatory na si corporation na magbigay ng dividends kay stockholder dahil kinita naman nila yon while holding their stocks in the corporation. When stock dividends is declared, no debt is created. Since stock dividends is distributed additional shares of stock, and because of the stock is part of the equity or capital and not an asset, stock dividends do not become liability when declared. The board establishes a date of record and a date of payment. Kumbaga dito wala naman silang obligation na ibigay sa individual stockholder na part of that corporate asset. Next, payment of dividend is not a matter of right. According to the Section 42 revised Corporation Code, prohibit the issuance of any stock dividend without approval of stockholders representing not less than two-thirds of the outstanding capital stock at a regular or special meeting duly called for the purpose. This provision underscored the fact that payment of dividends to the stockholders is not a matter of right but the matter of consensus. Siyempre, there must be approval of BOD in general rule. And when it comes to the stock dividends, BOD tsaka stockholders ang kailangan since the payment of dividends is nakadepende sa unrestricted retained earnings. Kung may profit ba or wala. And sa part of the stock dividends, kung papayag ba yung mga stockholders na madagdagan lang yung stock na hinuhold nila. In which need talaga ng approval nila kasi under name nila yung madadagdag na stocks. Siyempre, stockholders prefer na makareceive ng cash rather than stock dividends. So, need nila mag-vote. Yung sa right to receive dividend, nagkakaroon lang nito kapag nagkaroon ng official declaration yung corporation. Siyempre, karapatan ng stockholders na makareceive ng dividends based sa amount ng stock na hinuhold nila. Pero pag ang pinag-uusapan is whether magde-declare ng dividend or hindi at kung anong payment of dividend, it is a matter of consensus. When the stockholders is receiving the stock dividends, they are exchanging the monetary value of their dividend for capital stock. So yung stock dividend na makukuha nila is part pa din ng capital ng corporation. When we say capital, it refers to the value of the property or assets of a corporation. When the investor buys shares, the value of shares that they promise to buy when the share is released, it is called the capital subscribed. So ito yung natatanggap ng corporation upon issuance of shares. Yung capital subscribed, it can be more than the par value of the shares. In the case of stock dividends, it is the amount that the corporation transfer from its surplus profit account to its capital account. So dito, by declaring stock dividend, corporation flows back a portion of its unrestricted retained earnings, meaning yung monetary value ng dividend na dapat ma-receive ng stockholders ay hindi na distribute sa kanila since mas pinili nila yung stock dividends kaya yung part of the profit is plowed back or retained in the company either to its working capital or for capital asset acquisition. When stock dividends are distributed, the amount declared ceases to belong to the corporation but is distributed among the shareholders. Consequently, yung unrestricted retained earning ng corporation is mababawasan na din based sa based nga sa amount of dividends na dineclare. While yung stockholders' equity is mag-increase dahil nga tumaas yung stocks na owned by the stockholders. Ang gusto lang i-point out dito, in accordance to the disquisition of the GR number 127937, is yung treatment with regards to the capital stock as referring to legal capital. Legal capital is that amount of the company's equity that cannot legally be allowed to leave the business. It cannot be distributed through a dividend or any other means. The original intent of legal capital was to create a reserve that could be accessed by a company's creditors in the event of default. Dito napapasok yung trust fund doctrine in which kinoconsider that this subscribed capital out of the stock dividends are considered as trust fund for the payment of debts by the corporation. Until the liquidation of the corporation, hindi siya pwedeng i-distribute as dividend or yung subscribed capital cannot be returned or released to stockholders. Kumbaga, yung stockholders, dapat silang makareceive ng dividends from their investment and not from the investment itself, in which hindi mababawasan yung capital stock for payment of dividends kasi legal capital yun ng corporation. So, what are the limitations of dividends? First, the right to dividend is based on the duly record stock holdings. Ibig sabihin, magkakaroon yung investors ng right to dividends based dun sa specific number of shares na na-own nila. Hindi pwedeng sumobra or kumulang. If you have 100 shares and ang equivalent ng 1 shares is 1,000, you will receive 100,000. Second, the right to dividend is based on the duly recorded Second, the dividends among stockholders of the same class must always be pro rata equal and without discrimination, regardless of the time when the shares were acquired. The right of the stockholders to be paid dividends accrues as soon as the declaration is made. Dito, may equal participation in the distribution in which the dividends must be general on all stocks and the stockholders will receive based doon sa proportionate shares. So, yung directors, di nila pwedeng i-exclude yung iba na makareceive ng dividends. Ganun din sa stock dividends kasi yung discrimination na yun is illegal. Third and fourth, the right to dividend accrues even if there is no SEC approval. Then the declaration of dividends is discretionary upon the board of directors. Since yung board of directors yung governing body ng stock corporation, kahit walang approval ni SEC, pwede silang mag-declare ng dividends and nasa sa kanila kung magde-declare ba ng dividends or hindi, kahit may surplus profit yung company. Fifth, dividends cannot be declared out of the paid-in surplus and revaluation surplus. When we say paid-in surplus or premium surplus, ibig sabihin nito na benta ng corporation yung stock at a higher price. Di daw siya pwedeng i-declare as cash dividends because yung enter proceeds of sales of the corporation of its own stock even na benta siya ng mas mataas sa par value niya ay part pa din siya ng capital stock at hindi siya ma-considered na profits earned through the conduct of its business. Ganon din sa revaluation surplus, di din siya pwedeng i-declared as dividends dahil nga yung revaluation surplus related siya sa fixed asset in which nagkaroon ng increase in valuation such as land. Di ba lumalaki ang value niya kapag tumatagal? Ang reason is because of such appraisal, is subject to market fluctuations, is merely anticipatory of future profits, and may never be actually realized as an asset of the corporation by the sale of the property at the value it was appraised. Kailangan kapag ipambabayad na dividends is bona fide or without the intention to deceive. 6. Treasury shares cannot be declared as stock or cash dividends. Since nalaman na natin sa Section 9 na yung treasury share is nare-reissue or nare-reacquired, hindi siya pwedeng ma-declared as stock or cash dividends since the stated capital was not reduced when the treasury shares were acquired and does not increase upon their reissue. In fact, bumababa pa nga yung price niya pag binibenta. Now, now we are in the second paragraph of the Section 42, in which state the prohibition on retention of surplus profits. The general rule, stock corporations are prohibited from retaining surplus profits in excess of 100% of their paid-in capital stock. When we say paid-in capital stock, the full amount of cash or other assets that shareholders have given a company in exchange for stock. So when retaining surplus profits is in excess of 100% of the paid-in capital stock, kunwari, 1,500,000 yung retaining surplus profit and yung paid-in capital stock is 1 million, then the corporation is required to declare dividends. Kapag nagtatabi or nagre-retain yung corporation ng sobra sa 100% ng paid-in capital stock, the corporation may be subject to improperly accumulated earnings tax. It is a penalty tax upon a corporate tax payer for accumulating so much net income after tax beyond the reasonable needs of the business. Kaya lang naman sila nagpapato ng penalty taxes because kapag walang declaration ng dividends, walang kikitain yung government from the dividend tax that was imposed to the individual stockholders. However, the corporation are allowed not to comply in the general rule even nalagpas ng 100% yung retaining surplus ng kanilang paid-in capital stock. Pwedeng hindi mag-declare ng dividends due to the following exception. First, when justified by definite corporate expansion project or programs approved by the BOD, Here, your retained earnings are restricted and it is subject to the expansion project or programs of the corporation, meaning may paggagastusan yung retaining surplus profits. When the corporation is prohibited under any loan agreement with any financial institution or creditor, whether the local or foreign, from declaring dividends without its or his consent, and such consent has not yet been secured, dito, there is a loan agreement na hindi mo pwedeng gamitin yung retained earnings hanggat di pa na-fulfill ng company yung loan obligation. Third, when it can be clearly shown that such retention is necessary under special circumstances obtaining in the corporation such as when there is need for special reserve for probable contingency. Example nito is nire-retain yung surplus profits as a contingency plan, meaning it is a reserve under certain conditions will result in specific outcomes. It is usually used as a protection against a future change of plans when negotiating parties fail to reach an agreement. Let us now proceed to the Section 43, Powers of the Corporation to enter into management contract. Before we proceed to the requirements, we should first tackle about the management contract. Management contract is an agreement whereby a corporation delegates the management of its affair to another corporation for a certain period of time. Here, the corporation will lend its management services to manage the another corporation since the corporation can employ officers and agents to manage its business. There can be no objection to employing another corporation for the purpose. Also stated in the last sentence of the Section 43 that no management contract shall be entered into for a period longer than 5 years for any one term. The corporation can enter into management contract with another corporation or with parent corporation. If it is with another corporation, obviously it is allowed without the need of amending its articles of incorporation to enter into a management contract with another corporation, which refers to any contract whereby a corporation undertakes to manage or to operate all or substantially all of the business of another corporation, whether such contracts are called service contracts, operating agreements, or otherwise. Take note, it does not apply to management contracts entered into by a corporation with natural persons. In case of the parent corporation, usually, pag parent naman, nagmamanage ng subsidiary. So, usually yun naman yung nangyayari. So, they may enter into management contract. Now, in the voting requirements for the general rule, first, the contract must be approved by the majority of the quorum of the board of directors or trustees, and second, ratified by the stockholders owning at least the majority of the outstanding stock when it comes to the non-stock corporation, at least majority vote of the members of managing and managed corporation. Pag sinabing managing corporation, ito yung corporation na mag-aako ng responsibility to manage another corporation. While managed corporation, yung mismong corporation na ima-manage or under the management of another corporation. So dito, remember that for the general rule, need ang approval ng BOD or trustees and by stockholders owning at least majority of the outstanding capital stock or majority of the members of both managed and managing corporation. However, as provided by the Section 43, may mga qualification in case of the interlocking stock dividends, interlocking stockholders, and interlocking directors. Third requirement that the approval by the stockholders of the managed corporation owning at least 2/3 of the total outstanding capital stock entitled to vote or by
at least two-thirds of the members in the case of non-stock corporation, in case of interlocking stockholders and interlocking directors. So para mas maintindihan nyo kung ano yung interlocking stockholders and interlocking directors, mabibigay ako ng example. So example of interlocking stockholders, if A, B, and C stockholders in both X corporation and Y corporation, the managing and managed corporation respectively own 35% of the total outstanding capital stock entitled to vote of X corporation. The management contract must be approved by the prescribed two-third vote of the stockholders of Y corporation. Ibig sabihin lang nito kapag merong stockholders na nagre-represent ng same interest in both managing and managed corporation, own or controlled one-third of the outstanding capital stock with voting rights in the managing corporation, which is X corporation in the example, the management contract must be approved by the prescribed two-third vote of the stockholders of Y corporation or managed corporation. Kapag sa interlocking stockholder with one-third of the outstanding capital stock and voting right to managing corporation. When it comes to managing corporation, ganun pa din sa board of directors. Majority of the quorum sa stockholder, majority of the stockholder owning outstanding capital stock. Sa managed corporation, same pa din sa BOD, majority of the quorum, nag-iba lang stockholder which is two-third na siya ng vote owning outstanding capital stock or two-third of the members. Ay, wala pala siyang members. Two-thirds of capital stock lang siya. Next, the example of interlocking directors. If A, B, C, D, and E constitute the majority of the members of the board of directors of X corporation and also Y corporation, the bigger two-thirds vote by the stockholders of Y corporation is necessary. Dito, the extent of the shareholdings of A, B, C, D, and E in X corporation is immaterial. Kasi sa interlocking directors, majority of the members of the BOD of the managing corporation also constitute a majority of the members of the board of directors in managed corporation. When it comes to the approval in managing corporation, same pa din kagaya sa interlocking stockholders. Kapag BOD or board of trustees, majority of the quorum kapag stockholders or members naman, majority of outstanding capital shares or members. Sa managed corporation, board of directors or both board of trustees, majority of the quorum pa din, na iba lang ulit sa stockholders or members with two-thirds outstanding capital stock or members. So remember, in both illustration, the management contract need only be approved by the majority of the outstanding capital stock of X corporation or managing corporation. Kapag interlocking stockholders and interlocking directors, same pa din, majority of the quorum and majority of the OCS. Pag sa managed corporation, same pa din yung interlocking stockholders and interlocking directors. Pag sa board of directors, majority of the quorum, pero pag sa stockholders of a managed corporation, two-third of the OCS. Pag interlocking directors, pwede din siya sa non-stock corporation unlike ng interlocking stockholder na pang stock corporation lang. So, di ba sabi natin kanina sa last sentence ng section 43 is yung period management contract must not be longer than 5 years for any one term. These are the exception. Service contracts or operating agreements which relate to the exploration, development, exploitation, or utilization of natural resources in which itong mga to pwedeng magtagal more than 5 years depende sa kung ano naka-provide sa pertinent law or regulation. Remember that the management contract cannot delegate enter supervision and control over the officers and business of a corporation to another, as this will contravene in section 22, which lays down to the fundamental rule that the corporate powers of all corporations shall be exercised by the board. So same lang siya. Now let's proceed to the Ultra Vires Act of Corporation. When we say Ultra Vires Acts, it refers to the act of outside or beyond corporate powers, including those that may ostensibly within such powers but are by general or special laws prohibited or declared illegal. Ultra Vires Act is one not within the express, implied, or and incidental powers of the corporation conferred with the revised corporation code or articles of incorporation. It is an act which is not positively forbidden but impliedly forbidden because not expressly or impliedly authorized or necessary or incidental in the exercise of the powers so conferred. In other words, it is the powers of the corporation that are not given or beyond the revised corporation code. However, if the acts of or transactions within the legitimate powers of a corporation or are related to its purposes are said to be intra vires. There are three coverage of the Ultra Vires Act. First, those outside the express implied incidental powers of the corporation. Itong mga acts na to are merely voidable and may become binding and enforceable when ratified by the stockholders. The ratification by stockholders cures the infirmity of the corporate act and makes it perfectly valid and enforceable. In case na yung transaction dito is partly executed, an action may be brought directly on it, and relief has according to its terms. The acceptance of benefits arising from the performance of another party may give rise to an estoppel that will prevent the rejection of transaction. Second, those which are affected by the corporate representatives who act without authority. Dito, let's say for example, si Tan and Huy are incorporators of the corporation, and from more than 14 years naiwan sa kanila yung management ng company and yung board of directors hindi nagkaroon ng meeting during the same period. Since nga they are incorporators, naisipan nila na makipag-transact with third persons and incurred obligation for the corporation including yung loan na na-obtain from paper corporation. Yung na-issued na yung na-issued na yung checks for the loan, tsaka naman dinishonor nila Tan and Uy. Dito, the loan transaction are ultra vires acts. It is liable to pay the loan on the basis of the doctrine of apparent authority. The doctrine provides that the corporation will be stopped from denying the agent's authority if it is knowingly permits one of its officer or any other agents within the scope of the apparent authority, and it holds him out of the public as possessing the power to those acts. Pwede din ito yung secretary's certificate which empowers certain corporate representative in which nakasaad doon kung ano yung powers na granted lamang sa kanya. And once na nag-act siya outside dun sa powers na nakasaad dun sa Secretary's Certificate, that act becomes ultra vires. Third, those which are contrary to the laws, moral, and public order or policy, which is nasa Article 1306 of the 06 of the Law on Partnership. These acts become illegal ultra vires acts and subject to void. So that's the end of my presentation, and thank you and God bless.